Laura's got a secret, oh what a tale. She spins a wild story, sets sail without a sail. Fake baby bumps, she's got tricks up her sleeve, but the boys see through it, they just can't believe. Oh Laura, 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 what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise. Points her finger, you're the bad guy now. But truth's got legs and it's taken a bow. Her plans unravel like a thread on a spool. Life's not a game and you're breaking the rules. Lies and lawsuits, so what a show. But justice is coming, it's starting to grow. You can't win hearts with tricks or a fight. The truth shines brighter than a starry night. Remember, don't twist what's true. Life's much better when you just be you. Laura's learning the hard way it seems. Honesty's the hero in everyone's dreams. Oh Laura, Laura, what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all.
Hey, folks. Oh, yesterday was rough. Well, first of all, we had the sentencing of Edric Faust, and which I did not stream. I got home 8 p.m. yesterday and utterly spent. I watched it, but I would not have been able to add anything but things I might have regret saying. So I took yesterday off, so to speak. So, which means this what I'm now streaming to you guys was supposed to be streamed to you yesterday. It is David S. Gingera replying to the motion to quash. And well, there are a bunch that I am not only motion to quash. I'm currently trying to find, because he sent a reply to their motion to disqualify. And let's see. Yeah, it is the Hey Rob case, not the bankruptcy case. And so I need to change here. Well, I'm still feeling a bit of the aftermath of yesterday. So yeah, this is sort of, while I'm going to read this, while I am attempting to find David S. Gingera trying to stay on the bankruptcy case. Now, if anybody of you have access to it, please send it over. I know I have it somewhere, but I think I mislabeled it. But so yeah, I know this is very, very early for most of you. I mean, it's 7:30 a.m. on the East Coast. On the West Coast, it is earlier. Here it is 1:30 p.m. Yeah, I took half day off today because I worked so late yesterday. So, hello. Hey, little miss. Hey. Hey, good to see you again. Good to see you again. Hello, Becky. Happy Friday. Happy Friday. And Kristen Vasquez. Happy Friday, everyone. Happy Friday, everyone. And Grandma Ninja is here. Denise Sells is here. Crystal Justice. Pernilla. Amanda. And Tinkaloo, I saw earlier. Dan Grandall. And a lot of other people. And Christine Fortunato is here as well. And hello, folks over at Rumble. And if it works, hello over at X. Good to have you here. Yeah, happy Friday. Happy Friday. It's only Friday once a week. So let's celebrate. Later today at 5 p.m. Eastern, it is fundraising stream for Edric Faust appeals. And they are aiming high. They are aiming to hire Brian Steele. And Brian Steele has results, but he is also not cheap. Also not cheap. Geriatrics, good morning from the mountains of North Georgia. Hey! Blue Ridge Mountains. I've been there. I went to the, it's September 2024. I went to the Sasquatch Museum and Research Center in Blue Ridge, Georgia. It was amazing. Absolutely beautiful mountain. Absolutely beautiful. Also, sad history with the Trail of Tears. And sent a link to the court listener, Dr. where you can access the BK. Thank you, MG. And dun 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 dun. Hello, Mr. Jingles. Hello. Yeah. Yep. Hello, Mr. Jingles. Let's see here. Oh, there it is. There it is. Main document. And no, that's not it. Where is the reply? Is that a reply? There it is. Thank you so much. I need to download. There it is. Now, folks, now we have it. Okay, so what do you want to hear first? Do you want to hear the 17-page response to motion to quash? It is the Hey Rob case where Laura Owens claims she is so threatened by Hey Rob that she got what do you call it in over there in Arizona? It is not a restraining order. Well, it's sort of a restraining order because she's so scared, so scared. Or do you want to hear from the bankruptcy case where David as Gingera desperately trying to stay on the case as Laura's attorney in a limited scope? And thank you so much, MG Law. Oh, wait a minute. Oh, I saw something else here. Oh, folks, hold on. I just got a message from Mo. Do you want to do something fun like Laura today? And let's send Mo an invite. Oh, that's a bad phrasing. I said, I'm doing Laura now. Bad phrasing. It's 4:30 a.m. on the wet West Coast. Oh, Jesus. And Pernilla, hello from cold Malmö. Have you ever been here? Pernilla, I live 45 minutes from it. So, yeah, I used to live there as well. Way back when. And thank you, Kristen, buying me coffee. Let's see. Dun, dun, dun. Dun, dun, dun. Thank you so much. There. Oh, I got 2 coffees. That's amazing, from Kristen and from Joy. Thank you so much, both of you. That is so nice of you. And there, morning from Ottawa, Canada. Hello, Ottawa, Canada. I haven't booked it yet, but I'm actually in September. I'm going to Quebec, and I'm going out to the Viking settlement out in Newfoundland. And so I'm not booked yet, but probably in September. And hopefully I can go to Montreal and meet up with Ian Runkle. So that is the preliminary plan, at least. The preliminary plan. I was planning on going to East Coast USA, but with all the things that are going on politically with everything, and let's take a leap year and go to Canada, and I will return to the United States next year when every new rule is set. So, yeah. Okay. Mo says, if you're still around after Roundup. Oh, yeah. Mo is doing her weekly Roundup. Is that now? No. But that starts in 20 minutes, and she'll usually do an hour and a half. I have no idea how long this will go on. But hold on, let me do one of these things, start a poll. Which ginger ass motion? Hey Rob, motion, bankruptcy motion. Okay, I'll leave it up to you. Start poll. You have 2 alternatives. The Hey Rob motion first, or the bankruptcy motion first? Oh, Joy is planning to meet Ian in Montreal. See you there, maybe. Yeah, if you plan it for September, then let's try to make it happen. Oh, coffee. Oh, that's strong coffee. I need that today. So yeah, I'm going to do this stream, and then I'm planning on taking a nap or something of the sort before this afternoon's fundraising stream for Edric Faust. All right, the votes are going in. Hey Rob motion has a slight lead at the moment. But please continue to put your vote in. And I can the Hey Rob motion is the response to motion to quash. David S. Gingera of the Gingera Law Office is replying with images. With images. And where did I there. And the bankruptcy is David S. Gingera reply in support of motion to leave to enter limited scope appearance. And I mean, both are kind of equally stupid, but it's all up to... Okay, now the Hey Rob is taking the lead substantially. It's 67% against 30. So 2/3 of you want the Hey Rob motion. So, all right, Hey Rob motion it is. Ta-da! 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 Why are you turning your back against the audience, Mr. Jingles? Oh, well. as long as he's not doing his only cat moment. All right, folks, let's see here. David S. Gingera, Gingera's Law Office, PLLC, attorney for plaintiff Laura Owens, Maricopa County Superior Court, State of Arizona. Laura Owens plaintiff versus Hey Rob. Response to motion to quash. Plaintiff Laura Owens, Miss Owens, respectfully submits the David, you can't even take a dump respectfully. Submits the following response to Hey Rob's motion to quash. The issue for the court is simple. Does the First Amendment bestow an unlimited right to attack, threaten, harass, and terrify victims with online speech? This is, of course, hyperbole. What Hey Rob is doing is not unlimited. As explained below, the answer is clear. Absolutely not. Underlined in bold. Threats and harassment are not merely immoral acts. They are crimes in the state of Arizona, and they are subject to lawful restraint. For fuck's sake. Some odd context aside, this court's task is easy. The issues raised by this case have already been conclusively resolved by the United States Supreme Court and Arizona appellate courts. Sure. As these authorities explained, the right to engage in free speech is never without limits. I'm just saying it as he writes it. Underscored bold. That is particularly true in cases involving extreme, egregious, and vicious online attacks from an obsessive, mentally unstable individual, as occurred here. Really? Really? Mr. Gingera, you're going for mental instability? What's your fucking evidence? Numbnuts? Now, Gingera really, really likes to project mental instability on everyone who is against Laura Owens. And which is quite interesting, since Laura Owens is obsessively and compulsively faking pregnancies with men who don't want her. Will I bring Ian some surströmming? Oh, hell yeah. Now, I'm not sure if I'm allowed to bring it onto the airplane, but I won't check if I'm allowed to. Let's see here. Accordingly, the motion to quash should be denied. Ms. Owens should also be awarded her reasonable attorney's fees and costs pursuant to RS and Rule 39A and Arizona Rules of Protective Order Procedure. I thought here's the thing. Yes, he is representing Laura Owens pro bono, but attorneys still have costs. It's like the filing fees, office costs. So attorneys sometimes, the 3 hours I spent on this case cost this much electricity, and at this rate, and blah 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 blah. Sometimes you get stupid things like this in fees and costs. Introduction. The facts of this case are disturbing and present a textbook example of why Arizona has a strong anti-harassment and anti-stalking laws. Laura Owens is a 35-year-old resident who has never earned a penny in her life, according to her sworn statement in bankruptcy court, who has never lived by herself, and has always relied on her parents for money at 35. That's not in Mr. Gingera's motion here, but I thought I would add this as context. She currently lives at home with her parents, where, among other things, she provides for care for her elderly father, Ron Owens. Really, Mr. Gingera? Are you, under the penalty of perjury, asserting to this court that Laura Owens is an in-house provides in-house care for Ron Owens? Well, is she getting paid or reimbursed, or is it you can live in a casita and we pay for your food? That's a fucking income, you imbecile. You just put into official filing that Laura Owens makes a living taking care of her father. Is she licensed to do this? Is she approved to do this? Well, I don't really care, but this would be interesting for the trustees in the bankruptcy court. For 40 years, Mr. Owens was the This does not fucking matter in this filing, you numbnuts. What Ron Owens has been doing in his life has nothing to do with this case. Mr. Owens was a nationally recognized radio talk show host in the San Francisco Bay Area. Laura also rides horses and has published music, including songs about her love for dogs. Absolutely worthless in this filing. Absolutely worthless information. Worthless. It just adds letters on pages. Yeah, so here's Laura Owens when she doesn't starve herself for sympathy. This is Laura Owens on a horse, winning things that she claims she has no income from. And folks, suno.com, an AI song creator. This is just inspiration. I'm not claiming to impersonate. Let's hear. Woman named Laura singing about love for dogs. She can with overly obvious auto tune. What style of music do you guys think she would write? Give me a suggestion in the chat. Give me a suggestion. First, come on, folks. Give me a suggestion. Style of music. Style of music. Dun dun dun. Dun dun dun. Angsty pop. Yeah. All right. Angsty pop. In the style of angsty pop. Create. Oh, sorry, you guys were too. Oh, but those are great suggestions. I got the suggestions of New Age, Yoko Ono, scream music, pop. All right. All right. Let's see here. I got 2 suggestions.
Call my ex, got his voicemail, hung up.
Too good. Let's try this. Obvious, not obvious autotune. Let's see what we get here. Yeah, suno.com is an AI song maker. All right, let's see what we get here after a few attempts. Laura loves the dog park.
I tried to write love songs, they all felt wrong till I saw those big brown eyes drill on my new dress, zero finesse, but my lonely heart said hi. You don't text back, you just spin in the grass, chasing your tail like it's never in the past. Maybe I'm cracked, but it finally fits. Yeah, I think my soulmate fetches sticks. Laura loves the dog park, screaming your name till my voice goes dark. When my heart hits a high note, breaks the chart. Every bark, every bark, every bark can spark. Laura loves the dog park. Who needs romance in a rooftop bar when I'm slow dancing with a muddy heart? Every bark, every bark, every bark can spark.
Still implies she actually has a singing voice. Let's see here. In the style of Yoko Ono scream music. Let's see if we get something. Yeah. Now, if you want to try the Suno AI music maker, I have a link in the description. All the doggies, every doggies. Laura walking down the sidewalk, shouting at the pugs and the mutts. Their noses wet, their feet go tap, tap, tap. I marry every wedding tale, and every yes I do. I love all the doggies, all the doggies. Every nose, every tongue, every bark in the park. Pee on my shoes in the dark. Laura rolling in the dog hair, covered like a furry ghost. She kisses every sloppy face. Kiss the snow. I throw my heart like a tennis ball. Chase it, chew it, tear it apart. Every bite mark on my silly soul, it is a present from my happy heart. I love all the doggies, all the doggies. Every nose, every tongue, every bark in the park. I love all the doggies. Even when they pee on my shoes in the dark. Laura whispers in a broken robot voice, I choose you. Be the bride. Then she screams for 30 seconds. I love all the doggies. All the doggies. Tiny teeth, giant hearts, muddy paws on my chest. I love all the doggies. Let them roll, let them jump, let them chew on my vest. Yeah, this is just an inspiration. I'm not claiming this is actually Laura Owens, according to David S. Gingera. This is anything resembling Laura Owens' published music, including songs about her love for dogs. It's just inspiration. Oh. I'm going to send. I have to send this to Megan Fox. I have to. Oh, video generating video. Yeah, it will take some time. All right. Back to David as Gingera's actual. Hi, Nicola Cox. Well, I got inspired by David as Gingera claiming Laura loves horses, rides horses, and has published music, including songs about her love for dogs. So I got inspired, and yeah, and this is apparently her music album. Who? All right, let's continue. Defendant Robert Hey Rob is a complete stranger to Miss Owens. We don't care. The two do not know each other. We don't care, and have never interacted in any capacity. We don't care. The only knowledge Miss Owens has regarding Mr. Hey Rob is what appears in online searches. Oh, really? Unless she actually searched for it, she wouldn't have found it. Which goes to Hey Rob's, their motion to quash. They are not talking to her. They are talking about her. Clear difference in the statute. Online searches, and of course the acts of harassment by Hey Rob, which gives rise to this case. Mr. Hey Rob operates several social media pages, including an Instagram account and a small YouTube channel. Much of the content posted online by Hey Rob is nonsensical. Information that in context of this case is absolutely worthless. Again, for example, his Instagram account contains the video dated August 25th, 2024, which appears to show him driving through an Arizona neighborhood, albeit with the camera turned upside down. So fucking what? What does this have to do with your reply to motion to quash? So, contains no likes and no comments from others. So what? This only shows that you are actively searching for things to play pretend being offended by. That's all it does. Yeah. This destroys this here. The only knowledge Miss Owens has regarding Hey Rob is what appears in online searches. There it is. If Laura Owens actively searches for this, she has to actively search for it to come across it. This proves her claims that Hey Rob is actively seeking her out. It can't be harassment if you actively search for things to play pretend being offended by. Yeah, I agree. Many of Mr. Hey Rob's YouTube videos are similar in that they reflect little to no audience attention. And what do? They look for stuff 7 months ago. While not meant to disparage Hey Rob's popularity or lack thereof, it's clear that he's not a journalist speaking to a broad audience comparably to, say, the New York Times. So they pick out these. Now, folks, let's go to Hey Rob. Who has gained 500 subscribers since last time I was here. There. That's great. That's great. Now, what they have done is this. go to popular, and then probably scrolled to one of these pages. That's it. While if you look up here at most popular, oh, look at this, 1,000 views. 1,000 views. Now, Hey Rob deserves a lot more, and let's go check his lives. Popular, 80. Well, this is Nancy Guthrie. That's amazing. Good on you, Hey Rob. Good on you, Hey Rob. 86,000 views. That's amazing. I hope you monetized it. And then you have 2,000, 2,000, 2,000, 2,000. Yeah. And as you can see here, he doesn't just only talk about Laura Owens. See? As Mr. Gingera implies. Another fucking loss for David S. Gingera. In addition to his limited social media fame, it appears Mr. Hey Rob previously worked as an actor. So fucking what? This has nothing to do and has no place in a reply to motion to quash. And here's the thing, folks. Hey Rob actually even being on IMDb is a win. Folks, I've been an extra in 7 movies. I've been an extra. Well, TV production, movies, whatevers. And I don't have anything on IMDb. So for Mr. Hey Rob to actually have an IMDb with actually recognized movies, that's a huge accomplishment. And had not David S. Gingera notified me of this, I would not have known. And I know how hard it is to get into IMDb. Yeah. So he worked and got paid. Yeah. You're an fucking idiot, Mr. Gingera. Miss Owens and Hey Rob crossed paths at some point after late 2023 when Miss Owens filed a pro se paternity action against a man named Clayton Eckert. In that case, Miss Owens alleged she became pregnant after a brief encounter with Mr. Eckert. This allegation and the case writ large eventually gained massive attention on social media for 2 reasons. First, because Mr. Eckert was a former star of the popular reality TV dating show The Bachelor. The second reason the case drew so much attention is because Mr. Eckert accused Miss Owens of fabricating her pregnancy. That, and you, Mr. Gingera, this case, now, it did attract some attention. But you, Mr. Gingera, once you got involved, it literally exploded because you're a fucking moron who should not have a license to practice law. Hey, look at that! MG Law is writing in Swedish. And hello, Malin. Hello, Malin. After a 2-hour evidentiary hearing, the trial judge largely agreed with Mr. Eckert. No, completely agreed with Mr. Eckert, and ordered Miss Owens to pay nearly $150,000 in sanctions. The court also referred Miss Owens to the Maricopa County Attorney's Office, which later indicted her on several felony counts arising from the case, including perjury and forgery. Even though, Mr. Gingera, you know how many counts there are. You know you're a possible witness in this. You know what the actual charges are. And now he cannot not address it, but he desperately tries to downplay it. Absolutely desperately. As of the date of this response, the criminal case remains pending. Ms. Owens has pleaded not guilty and she has not been convicted of any crime. Correct. We can still opine about the case, can't we? The sensational nature of these allegations, no, it's correct. The charges and allegations, in my opinion, covering this case for quite some time, is, if anything, they are undercharging Miss Owens. As well as Miss Owens' status as the daughter of a former talk radio legend, I don't give a shit about Ron Owens and his fame in the 80s and 90s and early noughts. Absolutely could not care less. Hey, Bruce the Moose is here. Hey, Bruce. Hey, all the celebrities are gathering in my chat today. Hey. The story has generated headlines in major traditional media outlets. Yeah, which actually speaks against your reply for motion to quash, meaning this is actually nationwide and worldwide headlines and coverage. Although the unusual background story of the paternity case between Miss Owens and Mr. Eckert gives some context to why we are here, that case has virtually nothing to do with the harassment injunction sought by Miss Owens. Really? You're seeking this because Miss Hayrob, attended the hearings, takes the court records and talks about it in very, very flowery language. And you are here saying it has virtually nothing to do with it? Now, that is an opinion that comes very, very close to an outright lie, Mr. Gingera. In her petition, Ms. Owens explained that at some point it appears Hayrob became interested in the Owens v. Eckert story, as have many others. That much is not surprising and is certainly not unlawful by itself. What is unusual and unlawful about Mr. Hayrob is the degree, type, and number of obsessive, bizarre, and frightening posts he has made, which raise serious concerns regarding his mental health. Here it is again. Now, folks, if you are referring to somebody's mental health, you kind of have you need something more than an opinion. You need a psychiatrist or psychologist or therapist opinion. Now, maybe you can contact Hidden True Crime and John over there, because he doesn't care as long as he gets paid. He will make shit up for you, allegedly. Specifically, as Miss Owens explained in the petition, Mr. Hayrob has made more than 1,300 posts about her. Look at footnote 1. Hayrob has posted more than 150 additional times since he was enjoined from further acts of harassment. Making a post about Miss Owens does not necessarily mean Hayrob potentially created the content in the post. In other words, posting can include publishing both original videos, images, as well as reposting content. he has a playlist. Hey Rob has a playlist. See here. Yeah. Let's see here. Yeah. The playlist is, let's see here, view full playlist. Come on. There it is. No, stop doing that. Let's see it. Ketchup Court, 12 News, Schnitzelinja, Maricopa County Attorney's Office, Dave Neal, Court of Random Opinion, Megan Fox, and so on. Bruce the Moose. He's just collecting stuff in a playlist. That, you imbecile, Mr. Gingera, is not posting. I have a hard time. And here's the thing. Here is what he says in his footnote. Blah, 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 blah. Where's the citation? Where's the citation in law, case law, that says making a playlist constitutes made more than 1,300 posts? You need case law for this, you imbecile. And you don't. Because there aren't any. Blah, 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 which many appear to be entirely nonsensical and or containing disturbing images and or threatening sexual comments. Which ones? Here, which ones? Here he's asking the court to go into 1,300 posts and find it by themselves. For example, Hey Rob's Instagram page currently contains dozens of posts which show Miss Owens crying in distress, with her name feature in bright yellow subscript. This is from court hearing. This is from an actual court hearing. I have these pictures as well. They are hilarious when she fake cries. It's absolutely hilarious. This is not crying in distress. This is, or if this is from some kind of video she made. It's either a court appearance or a video she made herself. Paragraph F, blah, blah. This is, and here's the thing, Mr. Gingera. If you have a footnote, it stops here. This here is a separate reply to something concrete in the motion, of course. That should be up here instead of the absolute shit you are writing. Hey Rob has also posted filthy, disgusting sexual comment about Miss Owens on YouTube, such as example shown below. In this still image taken from a live stream video, Mr. Hey Rob displays himself alongside a variety of horse whisk extensions with Miss Owens' profile. This is funny. This is so funny. Sample products named include these. This is funny. This is sarcasm. This is protected speech, in my opinion. And here's another fucking footnote. From where? Where's the second footnote? That's footnote number 1. So he has this little, and he has a footnote that is longer. Okay. Footnote 2. Oh. All First Amendment lawyers understand that at least when they involve celebrities and general purpose public figures, the First Amendment usually protects jokes parody. See Hustler v. Farwell. Miss Owens is neither a celebrity nor is she a general purpose public figure. There's a debate going on what level of public person Laura Owens is. I would argue with the amount of videos, blog posts, her TED Talk, and her 2-year run as a podcaster. Yeah, I would say she is on the lighter side of the gray zone of what constitutes even a limited purpose public figure. That is my argument, at least. Now I know there is a debate if she is a celebrity. Fuck no. Oh no. No. Is she a general purpose public figure? I would say it's getting close, as she talks about her case through you and without you, Mr. Gingera, all the fucking time. So I would constitute it's the gray zone is in between a limited purpose public figure and a general purpose public figure. But that's up to the court to decide. Miss Owens is neither, blah, blah, blah. This matters because when a plaintiff is not a public figure, the protection provided by speech by the First Amendment may be much lower or even non-existent. This, I need an exact quote from a case. The U.S. Supreme Court and Arizona courts have also held harassment and threatening conduct may not receive any First Amendment protection at all. May. True threats of violence are outside the bounds of First Amendment protection and punishable as crimes. Counterman v. Colorado. Let's see what Counterman v. Colorado actually is about. Let's see here. Counterman versus Colorado. Beginning in 2010, Billy Counterman sent thousands of messages to singer-songwriter Cole Whalen that foreboded her death and followed her activities. Counterman was convicted of stalking in Colorado, with his conviction left intact by the Colorado Court of Appeals and Supreme Court. Under Colorado law, statements are not free speech if a reasonable person would view the statements as threatening, with no need to prove that the speaker had subjective intent to threaten. Yeah, but here it is. Thousands of messages to singer-song that foreboded her death. So, Gingera, you're quoting Counterman v. Colorado as if that would apply here. First of all, those messages was sent to that person. Here, Hey Rob is talking on YouTube Live to his audience about Laura, of which you yourself wrote here you had to search for. There's a clear difference here. All right. In addition to publishing the above comments, Hey Rob has done much more. As explained in Owens' petition, Hey Rob recently published a video in which he encouraged viewers to locate Miss Owens by contacting places he believed she might be. And by falsely impersonating her in an effort to verify her location. See petition at 2-3 describing the incident on 1/14/2026. See, there's no actual quote here. No quote about the January 14th. No quote. Hey Rob has also made threatening, demeaning, and insulting sexual statements about Miss Owens, stating he believes she belongs in prison. And see how this is not in quote. And that quote, the guards there will grape will say grape, while also referring her as a C-word whore. You see how all of these are in separate quotes? And also that this is the 3 dots here, meaning, oh, I removed every bit of context. Now, here's the thing, folks. The First Amendment is not there for speech you like. The First Amendment is specifically in place for speech you don't like. And describing hypothetically what happens to a person in jail is not a threat to Laura Owens. That is describing a possible consequence of her actions. And when it comes to these words, I believe I've said worse. But Gingera can't do shit about it because he would have to serve me over here. And the cost of international injunction orders is you can start at $50,000 to even attempt it. So, and neither of you fuckers have $50,000 to your name. Hey Rob has further described following Miss Owens to virtually every court hearing she has attended. No, not following. He attended court hearings. While expressing a desire to this. No. He has attended court hearings, and on 11/6/2025, at one point, Hey Rob described by something stupid Laura said that made him feel like he could fucking bitch slap her through the phone. That's a description of describing a feeling. That's not a threat to Laura. Based on these and multiple other harassing acts, Ms. Owens sought injunction relief from this court, which was granted on January 20th, 2026. Hey Rob now challenges the order on several grounds. As explained below, Hey Rob's arguments are not just without merit, they are at best frivolous and at worst intentionally misleading, if not outright fraudulent. Yeah, because you have such a great history with words in motions you have written. Not that long ago, Mr. Gingera, you got yourself in a bit of a shitter because Laura was found because of something you wrote. Either she was perjuring herself in court, in the Owens v. Eckert, or she was lying in that affidavit that you wrote, Mr. Gingera. So you might have gotten her an extra charge, depending on if Laura decides to take another perjury charge in the state case, or if she will be found to be lying to the federal court. The court should also order Hey Rob to pay Miss Owens reasonable attorney's fees and costs in an amount to be determined later. That's the second time he said, I want to be paid. Pay me. Finally, given the extreme circumstances of this case, and in light of evidence showing Hey Rob has continued to violate this court order after it was served, the court order is do not contact her. And he hasn't. To my knowledge, Hey Rob has never spoken, emailed, or attempted to contact Laura Owens in person or out of person. He covers the case with very, very flowery language. And here's the thing: if you believed Mr. Hey Rob has violated the court's order, where's that motion? Where is that motion? The court should refer this matter to the Maricopa County Attorney's Office for a determination regarding potential criminal charges to be brought against Hey Rob. This is him just copying shit. Oh, they did this to Laura, then the court must do it to everybody else. Fuck no, you imbecile. Such charges may include, among other things, violation of hours, use of electronic communication to terrify, intimidate, threaten, or harass. Here's the thing, you idiot. That is to directly contact Laura Owens, which he doesn't. I know this fucking you idiot. Criminal harassment, felony aggravated harassment, felony stalking, perjury, among others. This has now stepped over the boundaries of being a complete and utter asshole. This is just frivolous. This is just frivolous. And then, of course, discussion. Now, on page 9, this should have been a 4-page motion at most, if Mr. Gingera had the mental capacity to stick to the bare facts. Hey Rob's motion raises 3 primary arguments in his defense. The first is a factual argument, while the other 2 are legal. 1, I didn't do some of it. Yeah. Here's the deal, Mr. Gingera. If you're going to attribute certain words to a person, you have to be fucking correct about it, idiot. Hey Rob denies making some of the statements attributed to him by Ms. Owens. As explained below, this argument is at best intentionally misleading and at worst may constitute perjury. In short, Hey Rob has made every statement he is accused of. To the extent that he has denied this in a sworn declaration, the evidence appears to show he committed perjury in making that denial. Nah. 2, I didn't contact her directly, so that's not harassment. Hey Rob's second argument is purely legal, i.e. that Arizona harassment law requires the defendant to have direct contact with his victim before relief may be granted. This argument is a clear material misstatement of the law, which this court must firmly reject. Where's the quote? Where's the... Okay. All right, let's see if he actually quotes the correct one. Even if I did it, the First Amendment protects me. Here's the thing. He's using quotation. This claims that Mr. Gingera is quoting Rob in his filing. This is not something that was argued. This is not a direct quote. This is Mr. Gingera imagining a quote. Now, can it be done? Sure. Is it proper? No. Let's see. Each issue explained further below. Mr. Rob made every alleged statement. In his motion and supporting declaration, Rob accuses Ms. Owens of lying to this court about what he said. On that much, he does not mince words. Contrary to Owens' mischaracterizations and outright fabrications of what Rob actually said, nothing in those live stream meets the criteria of Rs 12-1809. Because this presents a factual dispute, it is not appropriately raised or addressed in the context of a dispositive motion. However, for the court's benefit, it is important to explain one thing as clearly as possible. It appears Mr. Rob committed perjury in his declaration insofar as he denied under oath making certain statements. That is a serious allegation, so let's be extremely specific. Using just one example. No. All right, let's just continue. Let's see if he actually finds something. Rob claims Ms. Owens falsely accused him of making several violent and offensive statements. Rob quotes each of these alleged statements and then denies making any of them, asserting the statements appear nowhere in the transcript, either at the time claimed by Ms. Owens or anywhere else in the transcript. He goes even further, stating the quoted statements do not appear in any other live stream Owens sites for that matter, emphasis added. And what does this absolute moron do? He takes a screen grab of his own on the first motion. Yeah, I know. There are no court ruling or police reports of anyone violating the protection order. I know. But he quotes himself here. Unfortunately for Rob, Miss Owen kept receipts, and those receipts shows two things. First, Rob did in fact make every statement Miss Owens has cited. This is not an opinion, it is a fact that can be easily verified by simply viewing the video, which will be offered in evidence at the hearing, which is available here. No, oh no. Sorry. No. Fuck. Oh, I hate this. Let's scroll down to where did it go? Gingera's law. Let's see here. Okay. Let's see here. First of all, where's the date? Where's the date? Where is the proffer that says this is authentic? And, folks, when you claim a specific quote, now he says here 1625. Let's see here.
Today, and they're both regarding the hearing, the debtor's examination of hello, the poor indigent. If she goes and says I'm indigent because the court said so, I'll fucking bitch slap her through the phone, through the.
He might, and here is why. 1625. Now he does say the entire quote. This is not a direct threat. This is hyperbole. Hyperbole. Okay, next one. Yes, she's a fucking twat. She's a hole. Yeah, she is. So? LO is a cunt, and recently a bloody ass cunt. Yeah. I needed to go hang out at the hospitals and found out if she was admitted anywhere or actually had surgery, not just hangnail up her ass. Hyperbole. Yeah, how is that a threat to her? It's not. Let's see. You're fucking. Thus, contrary to Hayrov's sworn denials, he did in fact make precisely the statement Miss Owens cited in her petition. These are not the only quotes. So isn't that weird? Because as this, I didn't do some of it. And then here, he selects a few of them to say, yeah, these he did. So ignore everything else we wrote. Idiot. That's based on this. Okay, where was it? Somewhere he wrote, he would just get, this is one example or something. Yeah. So he is cherry picking. And this is opinion. If she goes and says, I'm indigent because the court said so, and then hyperbole. It's a figure of speech. And this is pure opinion. Based on this, it appears Mr. Hayrob knowingly lied under oath when he denied making these statements. And here, look at this. You absolute moron. Look at footnote 3. In fairness, Ms. Owens did mistakenly attribute some of the statements quoted in her petition to the wrong source video. Ms. Owens' petition claimed Mr. and Bitslape's blah, blah, blah. This was a simple clerical error. No, that was you being wrong. You absolute idiot. The fact is incredibly ironic given that Ms. Owens has been charged with perjury. And although she has not been convicted of any crime, Mr. Hayrob has posted hundreds of videos calling for her to be convicted and sent to prison. Yeah! Which is an opinion based on the facts known. Idiot! He has also laughed about her being this while incarcerated. This is opining about consequences of going to prison. The irony and boundless hypocrisy cannot be overstated. The irony and boundless hypocrisy is you, Mr. Gingera, because if I would say this outright, if it weren't for Mr. Gingera, some of these charges would never have happened. Some of these charges would never have happened if Mr. Gingera had not been her lawyer encouraging her, in my opinion, to make these false statements under oath. In any event, Hayrob's first defense, denying that he made certain harassing statements identified in Ms. Owens' petition, is entirely groundless. But you say this, mistakenly attribute some of the statements quoted in the wrong source video. This is not a simple clerical error. This is you not doing your homework. B. Hayrob states the requirements of Arizona law. The second point raised by Hayrob is a legal argument regarding the statutory requirement of Rs. 12-1809, which defines harassment as a series of acts directed at a specific person. According to Hey Rob, videos posted on social media cannot meet that definition unless the defendant sends them to his victim. First, and then here again, what? First, although Hey Rob's videos are about Owens, they are not directed at her. Yeah. And here is quoting LaFaro v. Cahill, 2002. This argument materially misstates the law, putting aside the fact that LaFaro involved events which occurred in late 2000, more than a quarter century ago. The case did not involve statement published on social media. YouTube and Instagram did not exist when LaFaro was decided. Rather, LaFaro involved verbal public statements made by a political candidate to a small crowd in front of the Temp Public Library and at a polling station. What is LaFaro? LaFaro v. Cahill. Let's see that one. That's actually 2002 case. I know lawyers are bad with math, but for fuck's sake. Let me just skim through this quickly. The petition stated that Cahill had demonstrated he could be physically violent and requested the court to review his arrest record. Rs 12-1809, because the comments made by Mr. Cahill to Mr. LaFaro could be found annoying by a reasonable person. She modified the original injunction ordering Cahill to not initiate in-person contact with LaFaro. Oh, sorry. Here it is. Judge Hendricks found harassment under Rs because of the comments made by Mr. Cahill to Mr. LaFaro. She modified the original injunction, ordering Cahill to not initiate in-person contact with LaFaro. So, Mr. Gingera, who the fuck is misquoting the law here? Absolute imbecile. LaFaro involved verbal public statement made by a political candidate to a small crowd in front of the Temple Public Library and a public center. Yeah, but the statements were at the other person. Jesus Christ, you fucking imbecile. Given the ethereal and limited nature of words spoken to a small crowd, which are not remotely comparable to videos posted on social media, which remain visible to an unlimited number of people forever, the Court of Appeals held verbal comments of this type did not meet the statutory requirement of Rs 12-1809 because they were not directed at what? What the fuck is he saying here? The Court of Appeal. In light of this conclusion, we do not reach Cahill's additional statutory requirement as a matter of law. The evidence did not establish that he had harassed LaFaro. He's quoting a case where the Court of Appeals reversed it. Angelo, please tell me if I'm reading this wrong, that case wrong. LaFaro v. Cahill, 2002. It is in the conclusion point 4. Let's read it. Here it is. At the December 20th, 2000 evidentiary hearing before Judge Hendricks, LaFaro admitted that he did not know whether Cahill in fact had an arrest record. Cahill also testified at this hearing and stated he has never been arrested. Regarding the third incident alleged in his petition, LaFaro admitted during the evidentiary hearing that no contact with Cahill occurred on November 7th. Instead, that incident involved Cahill and another CRG volunteer. LaFaro was not present. Our conclusion is based on the facts of this case. We are not suggesting that a third-party conversation could never constitute directed at harassment pursuant to Rs. 12-1809. In light of this conclusion, we do not reach Cahill's additional statutory argument that, as a matter of law, the evidence did not establish that he had harassed LaFaro. We vacate the conclusion. We vacate the injunction against Cahill and order entry of judgment against LaFaro. Okay, so it wasn't overturned. But the facts of the case are everything here was directed at, which is not the case here. All right, given the ethereal and limited nature of words spoken to a small crowd, blah, blah, blah. Held verbal comments of this type did not meet the statutory requirements because they were not directed at the plaintiff. This holding does nothing to help Hey Rob. This is so because in the quarter century since LaFaro was decided, the Court of Appeals has established entirely different rules for dealing with people like Hey Rob, who use social media and the internet to harass, stalk, and terrorize others. Thus, although LaFaro remains valid law, the case is strictly limited to the facts it presented, i.e. verbal statements made offline to third parties do not meet the directed at requirement of the statute. This rule has no application here. This is just words. So if you claim this rule has no application, for fuck's sake. Here's why. In State v. Snyder, the defendant was charged with criminal harassment based on social media posts he made about the victim, an ex-girlfriend named BB. So, asshole, this was a victim of this person who then made verbal statements at the victim. You are quoting that as your argument? For love of fuck. Snyder argued the state failed to prove that he contacted or caused a communication with BB because he did not directly send BB any messages while her order of protection was valid, and BB only became aware of his social media posts concerning her when third parties showed them to her. Yeah, but you actively search for them. That's the difference. Another difference, in my opinion. The Court of Appeals flatly rejected this argument and affirmed the criminal conviction. Yeah, but again, asshole. Laura Owens is not a prior victim of Hey Rob. As you yourself stated, never met. There is no past victim here. Let's see here. Blah, blah, blah. Again, the court must stop and consider something astonishing. The defendant in Snyder was convicted of felony aggravated harassment. A conviction later affirmed on appeal. Because after he was ordered to stop harassing the victim, he posted a video on social media showing the order of protection with the victim's name and address on it. Want to guess what occurred after this court ordered Hey Rob to stop harassing Miss Owens? He committed the exact felony as defendant in Snyder. So this is what that he Googled. This is Lawrence show. You numbskull. This is not Hey Rob making a conscious act. This is Lauren showing the injunction. Oh, for fuck's sake. Snyder is not the only Arizona case to... for fuck's sake. This is so... Open link. Hey Rob re-streamed Lauren's stream. Okay, yeah. So yeah, let me see. So he quoted. Okay, let's see here. I'm just checking here if an actual address is found. Plaintiff Laura Owens, defendant. I don't see Laura Owens' address here. In that, there is not. With the victim's name and address on it. Exact same felony as the defendant in Snyder. First of all, Laura Owens is not a victim. There's no actual... Oh, for fuck's sake. Yeah, I understand. They weren't streaming. They were streaming at the same time. Yeah, he was restreaming. He was a guest who restreamed the stream to his own channel. But he's not actually revealing the address. They are talking about the court case during his the Lawrence fundraiser for his defense, which I also did. Snyder is not the only Arizona case that reached that conclusion. For instance, Raber v. Wagner. Let's see. It's a 2025 case. Let me just skim through it. Vacate opinion. Let me just skim through it here. This case, previously married. Ex parte order. And it further found that Wagner posed a credible threat to the physical safety of. Ordered, okay. Let me just skim through it here. Yeah, but here's the thing. The difference here is what I see in that is that they were previously married. That they had that history. Why? Oh, hold on. I thought the lighting was funny. The difference is the prior history in the cases. Yeah, they were on Lauren's stream, and he was co-streaming to his. He still would have no control over what Lauren put on screen. Exactly. He did not actually post it, so it's gone by that alone. The Wagner case involved a defendant who was accused of harassment by sending text and emails to the victim's friends, relatives, work colleagues, and other contacts. The speech in question was extremely tame compared to the disgusting vile remarks made by Herr Rob. Yeah, but it's a completely different situation. There's so yeah, I would strongly suggest that Hey Rob's attorney addresses these extreme flaws in Gingera's reply here. Okay, let's go to this. The First Amendment and the Arizona Constitution do not protect criminal harassment and similar crimes. The final point raised by Mr. Hayrob is a second legal argument that his conduct is protected by the First Amendment. Notably, Mr. Hayrob does not cite a single case from the Supreme Court or anywhere else which held criminal harassment is protected by the First Amendment. No, you don't have to. You have to show. First of all, here is Gingera is putting the cart before the horse. He's trying to conclude that this is criminal harassment. Fucktard. There's no judgment of criminal harassment. There is not. You have an injunction. This is not a judge affirming a jury decision of criminal harassment or a plea deal affirming criminal harassment. You are putting the cart before the horse, trying to tell the court that by your opinion alone, this is criminal harassment. But this is so insanely stupid. So his entirety here, this entire here, which is his baseline for his argument, is a straw man. And in my opinion, completely irrelevant. And in itself should get this tossed. Straw man is really, it's so stupid. That failure is hardly surprising given that the US Supreme Court has repeatedly agreed, provided the appropriate mental state recklessness is shown, harassing threats can be punished civilly and criminally in a manner consistent with the First Amendment. Yeah, but here, you're putting the cart before the horse. There is no such... Oh, for fuck's sake. Counterman versus Colorado, establishing recklessness requirement in a criminal case where defendants sent threatening Facebook messages to the victim. Two. This is so stupid. Consistent with US Supreme Court precedent allowing for criminal and civil punishment of harassing speech and conduct, Arizona courts have repeatedly explained harassment is not, blah, 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 protected speech. State v. Williams. Let's see what this is. State v. Williams. Arizona. Is it this Arizona case law? Okay, let's see here. Skimming. In March 2018, Snyder and BB1 met on an online dating application and went on a date. Boom, gone. Yeah. The baseline for what Gingera is trying here is gone there already, where they have a physical encounter. which led to later harassment. There is no such thing here. So that's already gone. To understand this conclusion, the court need only consider State v. Williams, which involve facts nearly identical to those here. Again. Or did I no, that was State v. Snyder. Come on. React all cookies. State v. Williams. This is 1996. He's quoting some 2018. Arizona App 2018. What the fuck is he talking about here? That's unpublished. Oh, for the love of fuck. It's not even published. State v. Williams, unpublished memorandum decision concerning social media usage, specifically how a user tags another person. It's not published. Oh. For the love of fuck, you absolute imbecile. You can't quote an unpublished. Unpublished is not case law, you fucktard. Jesus Christ, this is stupid. Williams involved a photographer who harassed the model primarily by posting comments about her on social media. It's not published, you absolute... For the love of fuck. Yeah, so I don't need to read any of this. It's not published. It's not case law. So what else is it? That okay, so Williams is his actual baseline, his foundation for his argument, and it's not published. This is so, yeah. So, oh, for the love of... this is so stupid. And David as Gingera signing. And the court should refer this to blah, blah, blah. And this is just him being an asshole because the judge in the Owens v. Eckert case referred it. So he's trying to have that done. And it's not going to happen. When your quoting is so bad, you're using case law that doesn't describe the situation, and you refer to fucking unpublished opinions. Here's the thing, which makes... Now, we all can think that David Gingera is a clown, which he is, that he is incompetent, which he is, that he might have guided Laura Owens towards a criminal prosecution, which in my opinion he did. But what makes him dangerous as a person is that he tries, as Laura Owens, to ruin people's lives. He did it by doxing Lauren. He does it by filing this, because this means extra costs to Hey Rob, who now have to have his attorney write a reply to this absolute shit. It's garbage. And I believe that is one of the goals for Gingera. That the harassment is, in my opinion, from Gingera and Laura. They are making people pay, literally, by filing this garbage, because they know people have to hire attorneys, actual competent attorneys, to reply to this garbage. And as Laura Owens did to Mike Maricini, and still does for over a decade, she has made him pay for not wanting her. And now David Gingera is applying the same strategy by making people pay for covering the case in a matter they don't like. Pisses me off. Really, really, really pisses me off. Let's see. Now, where were we? Yeah. All right. Time for the next case. This the another stupidity. But let's do a swoop. Yeah, yes, folks, that is the Norwegian fire-farting dragon swoop. You cannot sneak up on that from behind. And let's see here. I need to check one tiny thing first. Oh, look at, oh, wow. Thank you to Diana. Thank you so $20 via PayPal. Thank you. That is so nice. That is so nice. Thank you so much. That when was that? 42 minutes ago. 42 minutes ago. I'm sorry. I didn't see it until now. If you're still here, thank you. Thank you. Hi, YSL Kels is here. Thank you. Hey, good to see you. Good to see you. Oh. Laura needs a domestic relationship with the cleaning service. Yeah. We all saw that video from her, how her casita looked with the clutter she lives in, with alleged dog poo. Ugh. Ah. This is Diana. Thank you so much. Yeah, feed the Swede. And at my size, it takes a lot of feeding. Yeah. Oh, yeah, I know. Laura is mad because Hey Rob goes to the courthouse to get documents. Yeah. Yeah. Folks, if you haven't subscribed to Hey Rob, dun, dun, dun. Here he is. Here's the link to Hey Rob. And yeah, when we a couple of weeks ago, he had 1,200 something subscribers. Now he's closing in on 2,000 subscribers. So if you haven't subscribed to him yet, please do so. Please do so. All right, where we were at this. I have to share screen. Share screen. Dun, dun, dun. I will have to put it up. Oh, stop doing that. Dun, dun, dun. And add to page. All right. Laura Owens bankruptcy case. If you haven't heard about that, that is Laura Owens in an attempt to avoid having Clayton Eckert going into her finances. She made, probably on the advice of David Gingera, file for bankruptcy. File for bankruptcy. That is my opinion. I don't have evidence for it, but I would not be surprised. And what happens in bankruptcy court is that, you have to disclose everything. Every single item you have to disclose. And we on my channel, we have been listening to a couple of hearings. And the last one was absolutely phenomenal. The from the Department of Justice, the trustee who represents the creditors in Laura Owens' bankruptcy case, asked Laura Owens a whole bunch of questions regarding, well, you say you don't have an income 2023, 2024, 2025. Yeah, I made nothing. Well, on this affidavit, you said you made $83,000 from your podcast. Abba. You claimed under oath that you made $200,000 a year. And then she tried to blame Gingera, that she let him write the affidavit and signed it on her behalf. Oh no, but that doesn't matter because it's still you. David just represents you. It's still you under oath making this. And these are from statements that you made in court, statements you did in affidavits, and during the statement you made under oath, under the penalty of perjury. And then David S. Gingera, in an attempt to save himself, then filed a motion to enter limited scope appearance for Laura Owens in the bankruptcy case, where he argued, 60 days, but I can leave when I want, and I can stay if I want, which is absolutely ludicrous. I did a reading of the motion for leave. The trustees saying, no, he can't represent her. First of all, he is a witness now. Second of all, the law does not allow a limited scope appearance in a bankruptcy case. So this is David S. Gingera desperately in an attempt to save his own ass because he might be in trouble for, in my opinion, knowingly filing an affidavit to the bankruptcy court he knew was false, or helped Laura Owens knowingly file a false statement to the bankruptcy court. You can't do that as an attorney. You can't do that. Yep, counsel needs counsel. He writes these motions like their blog post. Yeah. So, okay, let's read this. United States Bankruptcy Court District of Arizona. In regard, Laura Owens, also known as Laura Michelle Owens, also known as Emily Laura Wilson. It's never good when you have an alias. Reply in support of motion for leave to enter limited scope appearance. And he starts with, let's recap. No. Undersigned counsel David S. Gingera is an attorney admitted to practice law in California and Arizona. As of now, counsel is admitted to practice before this court and has been practicing law for more than 25 years. Undersigned counsel would like to offer pro bono services to debtor Laura Owens, with the only restriction being as to duration of the representation. For reasons that appear purely performative and pretextual, counsel for the trustee objects to this. They quoted actual law. David, actual law and statute, not unpublished. Actual published law and statute. As explained below, there is not a scintilla of merit to the trustee's objection. Well, except correctly quoting case law. Indeed, the objection is both premature and ultimately it is based on a purely hypothetical issue founded on literally nothing but speculation. Well, Laura either perjured herself in a prior hearing, court, or she lied in the filing you helped her write and signed on her behalf. It's either or, making you a witness. Trustees Council also misstates both the law and the facts. Oh, you are claiming that the Department of Justice representative in this case for the creditors is lying. Oh, good luck with that. Because the objection is premature, speculative, and substantially groundless, this court can and should react it without prejudice to the issue being revisited later, when and if necessary. So he's asking them to punt it forward. Introduction. Once upon a oh, for fuck's sake. Once upon a time, lawyers were encouraged to provide free or low-cost services to the needy. This was not seen not as a burden, but as an honorable duty owed to the courts by all members of the legal profession. Their objection is not about you claiming to do this without monetary compensation. Has nothing to do with their objection. Quote, courts have long recognized that attorneys, because of their profession, owe some duty to the court and to the public to serve without compensation when called on. United States v. Acres of Land, blah, 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 blah. While few lawyers donate significant amount of time, the practice is still strongly encouraged. The Arizona Rules of Professional Conduct expressly says so. This has nothing to do with you being pro bono. It has to do with, can you represent her? One, since you are probably a witness, and two, they don't allow limited scope appearance. This court shares the view that pro bono services are a time-honored duty of the legal profession, and then, United States Bankruptcy Court pro bono honor roll. Despite its court's strong endorsement of pro bono services, the United States trustee asked this court to reject such an arrangement here. They don't give a shit about the pro bono. It's about you representing her in a matter where you have a self-interest in incriminating Laura, or because you signed an affidavit that either made her perjure herself and adding on another count in the criminal case, or the other is you filing something you know were false. So you have a self-interest in representing Laura here. That's the objection. Idiot. Why object? Counsel argued with virtually no explanation that the entire weight of the United States Department of Justice is unable to bear the identified needless complication caused by allowing an indigent debtor to receive some assistance from a sole practitioner. Some, yeah. No, that's the problem here. You either in or you're out. That's one of the arguments here. The other argument is that you are a potential witness. This argument is not only meritless, it's presented in bad faith. Oh, good luck with that. This court should therefore grant leave for undersigned counsel to appear on a limited scope basis in the manner requested in the initial motion. Discussion. A. This court rules do not prohibit limited scope representation. In its original motion, undersigned counsel explained Local Rule 9010-1C1 takes an all-or-nothing approach to appearance of counsel, i.e. when a lawyer enters an appearance in a bankruptcy matter, the lawyer ordinarily responsible for all aspects of the case until counsel withdraws or the case is closed. Despite this, the motion further explained Arizona federal courts routinely allow limited scope appearances. Yeah, but not bankruptcy. Jacobs v. Wheaton Van Lines. Oh, for fuck's sake, what is this case? Ninth Circuit. I'm just skimming through here. This is just a decision. The panel, in their opening brief, plaintiff failed to raise and therefore have waived any challenge to the district court ruling that it lacked subject matter jurisdiction over their declaratory judgment action. We will not consider any claims that were not actually argued in appellant's opening brief. I have to check here. Background. Moving company. Declaratory judgment. This is not a bankruptcy case. It's not a bankruptcy case. It is cost endued by some transportation of plaintiff's goods from New York to Arizona, dispute over payment, breach of this is a breach of contract case. It's not a bankruptcy case, you moron. What was the other case? Volta v. Winkle. It's a 3-count complaint. Let's see this. So I can look at the actual facts of the case. It's a lawsuit against multiple defendants. And it's a settlement for pro se Arizona prisoner. It's an assault case. It has nothing to do with bankruptcy. Neither of these cases are about bankruptcy. Oh, for the love of fuck. Is quoting, this is bankruptcy court. This is specifically about bankruptcy court. And you're quoting 2 cases that are not bankruptcy. Oh, for the love of. Yeah, of course. They're permitting limited scope appearances in federal court. Because it's not bankruptcy. In the face of this authority permitting limited scope appearances in federal court, yeah, federal court, but not bankruptcy court. The trustees argues the local rules strictly prohibit the limited scope appearance that Gingera's request. Yeah, in bankruptcy court. Notably, the sole authority cited in support of that position is the language of Local Rule 9010-1C1 itself, which of course is entirely silent as to whether limited scope appearances are allowed or prohibited. No! Oh, this is so misleading. Arizona District Court rule, blah, blah, blah. And he quotes, an attorney of record shall be deemed responsible as an attorney of record in all matters before and after judgment until the time for appeal expires or until, yeah, that's the local rule. And general appearance. An attorney who files a debtor's bankruptcy petition or who files a notice of appearance on a debtor's behalf must represent the debtor in all matters other than adversary proceedings until the case is closed. Yeah. And he's emphasizing district here and bankruptcy here. So he's mixing these 2 rules together and claiming it is district bankruptcy. Oh, for the love of fuck. Thus, in a district court proceeding, any lawyer who appears in any case shall be deemed responsible as an attorney of record in all matters. In contrast, the bankruptcy court version of the rule states that a lawyer who appears for a debtor must represent the debtor in all matters other than adversary proceedings. If anything, the inclusion of the words other than adversary proceedings makes it clear a lawyer who appears for a debtor in bankruptcy court accepts less responsibility than a lawyer who appears in district court. But what you are asking for, Mr. Gingera, is a time limited where you yourself decide if you want to be in or out. You want to be in order to help Laura with discovery for a limited time appearance. That's not what this is about. Despite this, and as was already explained in original motion, judges in Arizona District Court, which the arguably more restrictive local rule, have expressly agreed a limited scope appearance is not inconsistent with federal law or the federal and local rule of civil procedure. And then he argues, because bankruptcy court local rule is substantially identical. He's mixing them and cherry picks in order to get... No, that's not how this works. And what contrary authority does the trustee offer in response? A single out-of-jurisdiction case in Sear, 493 BR, bankruptcy. If counsel for the trustee had actually read Sear, which is admittedly a burdensome 92-page opinion, which undersigned counsel has now read, she would have known Sear not only does not support the trustee's argument, it supports exactly the opposite premise. Sear did not involve an attorney who requested leave to appear on a limited scope basis. Rather, Sear involved a lawyer who charged the debtor a flat fee for filing a Chapter 7 petition. Unfortunately, the lawyer failed to adequately investigate the debtor's affairs, so it has no bearing on this situation. Yeah, no, it actually does. Because the flat fee here made him... As a result, the Luca did not realize the primary debt owed by Mr. Sear was a judgment ordering Sear to pay sanctions in the amount of $67,000 for committing fraud on the court in a prior litigation matter involving a creditor called St. Rose Dominican Health Foundation. Noting in the underlying case, the trial court found Sear submitted evidence in the form of emails that he had embellished to boost his claims. Although the Luca claimed filed a Chapter 7 petition, who refused to represent the clients in an adversary proceeding filed by St. Rose, claiming this was not part of his representation agreement with Mr. Sear. Yeah, but... Mr. Gingera, you're not asking to be... your ask of limited scope is not everything but the adversary. You're asking for a time-limited appearance to help Laura Owens during discovery. It's not the same fucking thing. I have to check. This stream is currently not ad friendly to... yeah, I'm not surprised. So thank you, folks, who has supported this stream financially, because I will not get any ad revenue from this one. Now, I don't have ads while streaming, but I will have ads every 20 minutes or so for the rewatch or replay crew. So once I stop and then the stream, and then YouTube does it 1 to 12 hour, let's go through this video and see if it's ad friendly, then I can have an ad every 20 minutes or so. Yeah, as very ambitious. There was a definite start and stop point. Yeah, in his filing, he asked for 60 days. A 60-day time-limited appearance, which he himself would decide if he wanted to end it earlier or stay longer, which is not within his authority whatsoever. Okay, let's continue. The bankruptcy court subsequently ordered Mr. DeLuca to show cause why he should be not be sanctioned for failing to represent Mr. Sear in the adversary proceeding filed by St. Rose. In the lengthy 92-page opinion, the court analyzed a variety of Nevada ethical rules and determined that Mr. DeLuca violated several of them. As a result, the court sanctioned Mr. DeLuca by ordering to repay the flat fee he received from the debtor, Mr. Sear. Literally nothing in Sears supports the trustee's position vis-a-vis undersigned counsel request to enter a limited scope appearance in this matter. Very much to the contrary, the bankruptcy court explained limited scope appearances, which is referred to as unbundling, were entirely proper and permissible. Yeah, but you still have to go from start to finish of the case, but not the adversary part of it. That you don't need to. That's the limitation. Again, you're asking for a time-limited representation. The Sear Court then offered a detailed and extensive survey of how other courts, bar associations, and legal scholars address the issue of limited scope or unbundled services. After this review, the court concluded limited scope unbundled services were proper, at least when a lawyer seeks to represent a Chapter 7 debtor without also accepting responsibility for related adversary proceedings. Yeah, the adversary proceedings. Ultimately, the Nevada court found that the attorney DeLuca did not comply with all applicable rules when he sought to limit the scope of his representation to exclude adversary proceeding. Based on this failure, blah, blah, blah. Here, the trustees' counsel presents no argument and certainly no evidence to support a conclusion, like the one reached in Sear, that the limited scope representation proposed in this case will not comply with any ethical rule, legal rule, or other requirements. You're making shit up now, just as you go along. In addition, the trustee also offers a second baseless argument, i.e. that it appears that Gingra's proposed limited scope appearance would not cover issues pertaining to adversary proceedings. And then, okay, so what? You actually wrote that in a court filing? As both sides have noted, local rule is already very clear. A lawyer's general appearance for debtor in a primary bankruptcy case does not mean the lawyer also has also appeared in or is responsible for any adversary proceedings. Yeah. That's not their argument, jackass. It was never their argument. And then we go on to it. There is no conflict of interest. Oh, really? The trustee's second and remaining argument is that undersigned counsel has conflict of interest. This assertion is based on the trustee's mistaken beliefs about the statement Ms. Owens made during a prior state court litigation in which she claimed to have $450,000 in the bank account. To be clear, if the trustee were to file a pleading alleging Ms. Owens did in fact have $450,000 in the bank account and that she lied in the bankruptcy schedules when she failed to list those funds as present asset, this would constitute a clear violation of federal bankruptcy. No. I need... No, but... oh, for fuck's sake, Mr. Gingera. Mr. Gingera. Laura Owens did claim to have $450,000 in her checking account. There was no explanation in that evidence that it belonged to somebody else. That was something she said later. So, again, did she lie in that affirmation that she had $450,000? Or did she not? And here is where you come in, Mr. Gingera. This is the trustee trying to find out why, if Laura Owens is claiming to have no income, why did she in fact claim in another case that she had over $450,000 in her checking account? Why? That was the question. And that is where you come in, because you apparently have helped her draft these assertions to the court, that is what makes your conflict of interest, because since you helped Laura file this, you have an interest in itself, you as her attorney. In short, there's no pending adversary proceeding involved in the $450,000 issue. No, but this is that's not the issue here. That is not the issue here. Unless the trustee intends to lie to this court, or to bring a proceeding without first investigating the claims, this issue is purely speculative and hypothetical. No, but it is not about Miss Owens did in fact have $450,000 in her bank account. It is, did she claim to have it, swearing it under oath under the penalty of perjury? That's the issue. Not if she had it or not, if she lied about it. So either she has it and she's lying to the bankruptcy court, or she doesn't have it and she lied to the previous court. That's the issue here, in which you have a conflict of interest because you helped Laura Owens file both. And this, unless the trustee intends to lie to this court, for fuck's sake. Gingera, she's salaried. Now, she might be a private practitioner taking on this, which still said, well, the government will pay her. It doesn't really matter how many motions you make her file, the government is paying her. She doesn't care how many filings she has to do. This is not civil court anymore. This is Laura Owens versus her creditors represented by a trustee paid by the government. She doesn't care. What about how many filings you do? She will just reply. And if you heard how she asked questions of Laura Owens, she's a badass attorney. Real badass attorney. Way out of your league. Well, then again, almost everyone is. But even if it were not, the trustee's position is based on a clear and material misstatement of the law. Specifically based solely on the potential future hypothetical possibility that an adversary proceeding might be forthcoming and might someday be the subject of a trial. The trustee suggests this mere possibility per se forbids undersigned counsel from having any role in this case. I don't think that's the argument. The argument here is you were involved in both filings, which clearly has you in a conflict of interest. Because Rules 3.7 of the Arizona Rules of Professional Conduct, which applies to attorneys appearing in this court pursuant to 9010(1)(a), prohibits a lawyer from acting as an advocate for a client in a case in which the lawyer is likely to be a necessary witness. What the rule actually says is something entirely different. A lawyer shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness unless the testimony relates to an uncontested issue, the testimony relates to the nature and value of legal services rendered. So he's underscoring at a trial. So it's okay to be verbatim about the rule here, but not above. Okay, interesting. Let's see here. Let me just check one thing. The disinterested bankruptcy, conflict of interest, disinterested requirements, adverse interest. Oh, this is a lot to read. Yeah, let's just continue. I do believe he's absolutely fucked up wrong here. By some terms, Arizona Ethical Rule 3.7 never prohibits a lawyer from assisting a client in pre-trial matters simply because the lawyer's testimony might later be needed at trial. Let's see here. Where's 3.7? I wonder if there are. Sorry, here I'm just skimming through here. Sorry if I'm conflict of interest, current clients. Well, she is not a current client. He is asking to be for representing her in this matter as well. These are more about if he represent different interests, but in this case, the different interest is himself. Yeah, but this is about withdrawal as the lawyer witness rule 3.7. That is if he is currently representing her. He's asking to be representing her with a known potential conflict of interest. So the rule 3.7, I would say, still applies in the regard that it prohibits him with a already known potential conflict of interest. It is in the court's interest to not allowing him representing her. That is my, at least initial that is my initial That is my opinion, at least. But maybe the trustees should clarify that. I don't remember how clear they were in there. So maybe they actually need to clarify that. But what Gingera says here, the rule is simply irrelevant here. Claiming first, there's no actual adversary proceeding pending in which undersigned counsel is likely to be a witness. The mere hypothetical possibility of potential future action does not implicate in the rule in any way. Second, even if there was an adversary proceeding filed, that matter is not scheduled for trial. The rule does not prevent a lawyer from assisting a client with pre-trial preparation, even assuming the lawyer becomes a trial witness. Now, but then you should. Here is what I believe Gingera fails. He tried to stay out of it, but the moment he realized there was a conflict of interest, in order to protect himself, he tries to insert himself. But the rules are primarily about a lawyer already representing the client when the conflict of interest arises in the bankruptcy court. That is how I interpret this. But do not take my word for it. Maybe the trustee actually has to clarify that, unless the trustee wins on the first prong here, that no, you can't represent her in a time-limited scope. Third and finally, if a future adversary proceeding was filed, which could only happen if the trustee intentionally violates the and if the case was set for trial, ER 3.7 would still not preclude the undersigned from acting as both an advocate and a witness at trial, because the exception of both ER 37A and 37C would apply. The underlying issue relating to the $450,000 will not be a contested issue. And here he's trying to make it into the fact that does she have it or not? No, that's not the issue here. The issue here is there are conflicting statements. One in the Owens v. Eckert under the penalty of perjury, and one filed to the bankruptcy court, which does not align, and both are sworn under oath as true, which they can't. And you, David S. Gingera, helped Laura write and file them both. That's my interpretation, at least. Conclusion: the trustee's objection to undersigned counsel request to enter a limited scope appearance in this matter has no merit. The motion should be granted and the trustee's objection overruled. First of all, I hope to everything holy that the judge in this case orders a hearing, because listening to the trustee, the attorney, questioning Laura Owens. And here's the thing: will David represent himself, or will he get counsel? Will he say he has to, or feel that he needs to pay up? But again, he's broke as fuck himself, because who wants to hire that asshole? I don't know where he makes his money from, or if he has a lot of savings. I have no idea how he pays his rent. I literally have no idea what he does to pay his rent. But I hope to the almighties that there will be a hearing. Because there's one thing to put it in writing and send it off. It's a whole other thing to do it in court, in front of a judge, with the trustee asking you questions. Oh wow, this 2.5 hours and 2 absolutely ridiculous filings from David S. Gingera, where he quotes unpublished opinions, which is not case law. In here, he tries to move the goalposts. He does a straw man. Yeah, I don't think this will end well for Mr. Gingera at all in the end. It might buy Laura some time, but I don't. The ending is inevitable. In this case, Clayton, Greg, Mike, Rob, they are like the Infinity Stones. And the court is Mr. Stark getting the glove and going at the end. And Mr. Gingera and Laura Owens are the bad guy, who in the end will lose. In a spectacular way. Spectacular way. All right, folks, that is what I had for you. I will redirect you to the fundraiser tonight at 5 p.m. The fundraiser is Edric Faust Appeals fundraiser. I will have guests. I already have Jim, a happily angry lawyer. Kat will most likely show up. I'm trying to get Sylvia, trying to get Melanie Little over here, and hopefully, Mr. Cruz, Attorney Cruz. The goal is to have all of them here on a panel regarding Laura Owens. No, Edric Faust Appeals Fund. Edric Faust is aiming to hire attorney Brian Steele for the appeal. And if we can make that happen, what is originally a better than average chance of successful appeal will become an even greater possibility that Edric Faust, who I believe is wrongfully convicted, will get justice in the appeals court. Again, thank you so much. Thank you. Thank you to Diana for your $20 via PayPal. That is so nice of you. Thank you to Joy, who bought me a coffee. And thank you to Kristen Vasquez, who also bought me a coffee. That is so valuable for me to keep running this channel. Thank you. Now, I usually end up with the Laura Owens song, which you all know. But today, if you haven't heard it yet, if you came in here later, in the filing, in the first filing we read, we heard from David S. Gingera that Laura Owens makes music about her love of dogs. And of course, I could not help myself. I made an AI song in the style of, let's just, how I believe and how my inspiration was thanks to you guys. Yoko Ono screaming style about her love for dogs.
I love all the doggies, every doggies. Laura walking down the sidewalk, shouting at the pugs and the mutts. Their nose is wet, their feet go tap, tap, tap. I marry every wagging tail, and every yes I do. I love all the doggies, all the doggies. Every nose, every tongue, every bark in the park. I love all the doggies. Even when they pee on my shoes in the dark. Laura rolling in the dog hair, covered like a furry ghost. She kisses every sloppy face. Kiss the snow. I throw my heart like a tennis ball. Chase it, chew it, tear it apart. Every bite mark on my silly soul is a present from my happy heart. I love all the doggies, all the doggies. Every nose, every tongue, every bark in the park. I love all the doggies. Even when they pee on my shoes in the dark. Laura whispers in a broken robot voice, I choose you. Be the bride. Then she screams for 30 seconds. I love all the doggies, all the doggies. Tiny teeth, giant hearts, bloody paws on my chest. I love all the doggies. Let them roll, let them jump, let them chew on my vest.